Welcome. It's Data Privacy Day. My name is Jocelyn Aqua. I'm a partner with PwC based in Washington, D.C. I'm here with three privacy experts to talk to you today about the California Consumer Privacy Act. It's a law that passed in June 2018. It is scheduled to come into effect in January of 2020. It's going to have a significant effect for U.S. companies and will really alter the privacy landscape in the United States, both in California and really throughout the United States. I'm here with Alistair McTaggart, who really was the force behind the California law. Justin Antonopoulos, a former Obama official who has recently left the government and helped found as a CEO of Wirewheel. And John Ackerley, who also was a former government official and has been working for the past few years on working to help keep companies secure with his company Virtue. This is the first in a series of conversations about the California Consumer Privacy Act, and we're excited to get started and talk to you today about what the law means and how companies are working to implement it. First, Alistair, can you give us a little bit of background about yourself and how you became involved in this passion issue for you?
Thanks, Jocelyn. My name is Alistair McTaggart, and I'm the chair of Californians for Consumer Privacy. That's the group that put the ballot measure together, which ended up resulting in the California Consumer Privacy Act. And I just wanted to say at the outset, explain a little bit about why I'm here with you and Justin and John. First of all, I take any opportunity to explain the law. I'm proud of it. And then second of all, I want to make it very clear, I have no financial relationship with any of these companies here, with Wirewheel, Virtue, PwC. I'm just here to explain the law. But I wanted to take this opportunity because these are three people who've spent their careers in privacy, real true privacy experts, and they're all engaged in efforts to try to help businesses comply with this new wave of privacy legislation that's going on around the world, which is happening as consumers around the world wake up to what's happening to their personal information and try to take back control over their privacy information. But I just wanted to say that at the outset that I have no financial interest in any of these folks here, businesses. And then in terms of how I got involved, I think this is just one of those situations where I thought this was a really important issue, and it seemed to me that this is one of those rare instances where someone could do something about it. Because of the situation here in California where we do have the ballot process where anybody can come up with an idea, and if you have the resources, you can put something on the ballot. Even though this isn't something that the tech industry welcomed initially, because we have the ability here to appeal to the voters directly, that piqued my interest, and I think that's really why we got here. It was an initiative that I spent 2 years researching. Ended up at the end of 2017 putting it on the starting to gather our signatures in early this year. We had overwhelming support. Over 630,000 Californians signed the petition to put it on the ballot. We never polled less than 80%. I mean, this is an issue whose time has come.
Yeah, definitely.
And so that's how we got involved. And then what happened is the legislature stepped in, and there's a provision in California where the proponent can withdraw the initiative if presumably the legislature acts. And so the legislature acted in June, and sort of the deal we struck was we actually got even more privacy than we'd had in the initiative. And as a result, we withdrew our ballot measure, and so it went into force in June. And as you said earlier, there was a cleanup bill in August, but it's now the law of the state. So that's.
Do you think maybe you can give us just a few minutes of an overview for those who are not as familiar with what the CCPA requires?
Sure. There are three main provisions of it. The first is transparency, finding out what companies have collected about you. And so one thing to think about, this law only covers businesses, and it only covers sort of medium to large businesses or data brokers. Businesses have to have over $50 million in revenue, or collect a certain number of personal records of people's information a year. So it's really only it's not addressing mom and pops, it doesn't address startups. And so the first thing we thought is, you, the consumer, would want to be able to find out what information the company has collected about you. So that's the right to know.
Right.
The second part is the right to say no. And that is, once you found out what information these companies have collected about you, it's being able to say to the company, hey, you know what? Please don't sell that information anymore without my permission. Or I just can opt out and just say, please don't sell that information. And then the third major piece is the sort of right to have your data kept securely, the way you'd want it to be kept. So that one, it says to the companies, you better keep it safe. If you're going to collect my information, fine, but just keep it safe. And so those are the three major rights. There are some other ones. There's the right to delete your information that you've posted. Mm-hmm. It's not like the European right because we have the First Amendment in this country, but still, it's a powerful right to delete information you've posted. There's a right to, it increases the age for opt-in for collection of information for minors up to 16 years old. And so it's really a landmark piece of legislation. It's by far the most comprehensive privacy legislation ever passed in this country. And I think, as you said earlier, as California goes, so will go the nation here. So I'm really excited about it.
That's great. So Justin, you started for many years as a privacy professional in the government, in the public sector. You left in 2016 after working for the Obama administration, and now founded your own privacy-focused company, Wirewheel. Can you tell me a little bit about what made you decide to do that?
Yeah, I mean, I had the honor of going all over the world and representing the United States on data privacy issues. And when you start to step back and you look at how important this issue has become, as Alistair was saying, to human beings all over the world, it really has become a fundamental human right everywhere. And you see laws being passed in Singapore, Japan, and India, and you really got the sense of how important it was. I actually started when I was a kid doing privacy cases for the Public Defender Service, under the Fourth Amendment and under the Fifth Amendment, and I knew how important privacy is to people everywhere. And when you see it's a fundamental human right, and you see how hard companies are trying to get it right in many ways, like there are a lot of companies out there that are trying to do the right thing. And I saw an opportunity where you could go to small businesses and give them technology and the tools where they could understand exactly what Alistair was saying. They could understand what data they were actually collecting or observing about customers. You could show them where they're storing it and where it's actually being, processed, where the computers are running. You also got a chance to show companies how it was being shared, where it was going and why. And that was a really awesome opportunity. We have on our team not only privacy experts, but we have folks who understand big data and application development and machine learning, and you need to bring technology to the problem in order to give folks the chance to be able to comply at scale. So I guess I come at it from the proposition that I think it is a right, and I think it's going to be something that everybody worries about, not only for us, but for our kids and our friends. You can see that it's a huge international issue. I'm excited to be here where you see the United States starting to take a leadership role on privacy too, because if you don't do that, you're ceding the law to be developed by the rest of the world. And I think that's a lost opportunity, to show how much the United States really cares about it. And I wanted to bring technology to the challenge, and I think that's what we're trying to do at Wirewheel.
That's great. And similarly, John, you were also in the government and worked with big data sets and dealing with privacy compliance issues in the federal government, and have come out and tried to build a company, Virtue, who really focused on security, encryption, in order to keep data safe. Tell me a little bit of what made you decide to make that move.
So first of all, it is a real honor to then be here today. In 2019, data privacy is foundationally a core societal issue around trust, and to be with the architect of the CCPA that is really driving the conversation, and with Justin, who worked in the Obama administration, I worked in the Bush administration, really partnering to bring technology to in a very simple way solve this problem. Really marks a sea change. This is a white knight issue, a nonpartisan issue. And for me, it started 20 years ago, actually, when I was right out of grad school working in Austin, Texas on the Bush campaign. And then Governor Bush instinctually was very pro-consumer. And the internet was just coming mainstream. And he saw, and then we saw that there was a role for there to be very simple rules of the road to give the consumer basic rights like being able to opt in before any data would be reshared or resold. Fast forward from the campaign, and I was in the White House as the lead technology advisor. We spent those first 9 months of 2001 really putting the finishing touches on our campaign policy positions. And literally on the morning of September 11th, 2001, was briefing the Deputy Chief of Staff around a briefing in the Oval Office that was going to take place on September 13th. Obviously, the world changed 2 hours later, and the focus of then government was how to use the internet to fight the war on terror. And consumer rights, consumer privacy went right to the back of the bus. And the Patriot Act rolled through, and this was before Gmail, this was before the cloud, this is before Facebook. Really consumer privacy was a casualty of September 11th. So fast forward 20 years to now be in a place where we can have a real impact and to deliver technology that can allow companies to then simply comply and do the right thing. It's just fantastic.
So that's interesting because I come from the government as well and have a little bit of a different experience. I spent from my career from 2002 to 2013 working on compliance and privacy issues with the intelligence community and the government. I witnessed firsthand in being a point of contact on data privacy with the Europeans, how U.S. citizens and Europeans really felt about privacy within the government post-Snowden.
Yep.
And that issue really did make a sea change in how the government protected privacy and made it more transparent and clear. So some of these real privacy concepts in the federal government are very, very similar to what you were thinking through as you started crafting this privacy law in California, especially these rights for individuals to seek access to their data, the right to know what's happening. Can you elaborate a little bit on basically that right to know?
Sure, and I think one of the things that's interesting to think about is the opportunity here was because California is so big, 40 million people, 1 in 8 Americans living here. That's the thing that triggered my interest, because you're talking about the federal government, hard as we all know to get anything done at the federal level. It was really apparent to me that if we got something done in California, it's too big an economy, the 5th largest economy in the world.
Exactly.
Businesses couldn't just then say, well, we're going to wall you off. If we'd been in a tiny little state, that would have been a different matter. So that was sort of the appeal. And then I think the thing I like about our approach is, I'm a business person. I've been a business person for 20 years. My first approach was, let's make it sensible, let's make it effective, but let's make it common sense, right? And let's make it actually work. And so the first thing is the right to know you're asking about. That's a pretty simple idea, right? And it's like, what would you like? Everybody wants to know what these companies have collected about them. And the thing that I think that this is, you're seeing this across the world, all the privacy regimes that are now being talked about, whether it's India or Singapore or China or the GDPR, which is the well-known European one that just came into effect in May. That's the foundational, fundamental starting point. You got to find out what these companies have collected about you, and so that's what really we say to the companies is you have to tell people what you've collected about them, because it's one thing for Uber to know where you are and to know where you're going and where you normally show up, and that kind of makes some sense. Once if you start to find out that they're collecting things that don't make any sense to you, what you had for dinner last night or what your sexual orientation are, you might start to think that's a little weird. Now, I'm not saying that's what I know. We don't know this yet, but it'll be interesting to find out once we start to be able to have this access.
So that sounds like a very simple premise, that companies should be able to tell you exactly what they're collecting. I think from my experience, from the experience of Justin and John, that it's not so easy. that companies are really having a hard time, and maybe companies that really had to think through the application of GDPR and how they had to comply with GDPR have a head start here. But the fundamental understanding of where is your data, what you're collecting, who you're sharing it with, has proven to be quite difficult for many companies. They have, some companies have purchased other companies. They have old systems. There's been turnover. It's really hard to keep track. And so basically one of the first things that has to happen, and has not been as easy for many companies, is really trying to understand what they have.
And I think that's one of the problems. When you can't turn around without finding about another data breach. 150 million Americans here, 300 million Americans here. People are tired of this, and one of the problems is these companies don't even know what they have. They don't know where they're storing it. They're not paying attention to it. They're storing it in plain text. It's time that someone said to these companies, guys, if you're going to collect all of my personal information, keep it safe and know what you have.
And I think, so I would argue, I think that most companies are there. They understand that now. And now they're trying to figure out what to do. So they know their customers, their clients, their employees want them to be more respectful of this data. And they have old systems and old practices, and they're trying to figure out, what do I do now? What are the next steps? So Justin, this is what you have to think about every day. This is what your conversations with your clients, trying to figure out what they can do now that they have this clear regulation that tells you that you really need to provide this right to know, and which requires some transparency. What are the next steps?
Sure. The right to know is, honestly, it's a critical thing. And Alistair's right. It's part of every privacy law around the world. And one of the things we looked at pretty early on is when you go to companies, when you look at all of the different kinds of laws, it's a little hard to know where to start. And we focus on 4 critical things at Wirewheel. What is the data that you're collecting or observing? And most companies have a general sense of what they're collecting. The observed data can often be trickier because there's so many systems that sometimes are collecting data that you might not know what exactly they're collecting. I think that's part of the reason that CCPA is so important, is it just makes it a persistent requirement, and it's a downstream requirement. In other words, if you work with a partner, they also have to start telling you what they're collecting and observing. So the first thing, again, is what data are you collecting or observing? The second is, where are you storing it? It actually does matter, and it's because not only where in the world is it, but also gives you a pretty good understanding of the security around that data. So you need to know where you're storing it. The third, and this is something a lot of companies don't pay attention to, is where is the compute, where is the server that's actually processing it? That actually matters for a lot of international law. And a good simple example is, if you're storing the data in Europe and your servers are running, or your cloud servers are running in the United States, everybody in the world treats that the same as though you move that data to the United States. So you just need to know both where you're storing it and processing it. And then the fourth thing is, who are you sharing it with and why? And those are the 4 things we've really focused on. What are you collecting, observing? Where are you storing it? Where are you processing it? And who are you sharing it with and why? And there are some ways that we have really focused on to help companies actually collect this information from what I call is the top down, being able to survey their people, ask them what they're using it for, ask them what they're collecting, and then also to plug in from a bottom up where you're using their own technology to help them understand it. And for example, the cloud is a huge accelerator for innovation. It's driving the ability for companies to solve problems in a way that they couldn't. If you talk to folks that came out of the military 20 years ago, they would tell you that a lot of the innovation that's happening right now, 20 years ago, would have had to have been funded by the military or by the intelligence agencies. But now, as a startup, you can buy incredible computing power and processing reasonably. And what we are doing at Wirewheel is trying to use that same technology that companies have purchased to help them find their data, find where it is, where it's being processed, in a way that even small and growing businesses can buy it reasonably. That sort of insight. So I think if you take a top-down approach and a bottoms-up approach to the problem and you use technology to bring it together, you can actually bring that kind of technology even to smaller companies.
It's a year until this law is going to come into effect. What are you seeing as the major technical challenges for companies?
That's a great question. And I often think about not only large companies, but growing and small businesses. What are some of the challenges they're going to have technically? And by the way, this applies not only to California, but every company that I meet wants to do business on the world stage, and these similar requirements carry through. One of the hardest ones is, who are you actually sharing your customers' data with and why? And there are two technical things that I'll highlight. Most companies are not building their applications or the products, the technical products they build from scratch anymore. They license services, and that means for authentication, you might be licensing a technology that another company built. That's a good example. Rather than building your own authentication engine or your identity management engine. If you've licensed a company's service like that, that means you are responsible for that data, even as a small and growing company, and you have handed your customers' data to another company. You need to know that that's happening. You need to know who those partners are before you share the data downstream. And that kind of thing can be really hard for a company to get on top of just because of the number of different services that companies are purchasing so that they don't have to build it themselves. So that's one technical challenge. Another technical challenge is setting aside the services you buy. It's how data is shared, because it's shared often through what are called API layers, application program interface layers, and that's a phenomenal enabling technology that enables companies and applications to speak to one another. But the result is that data is being transferred from one company to another, that company to another company downstream. And when you get to some of the requirements, including around deletion, where it's fundamentally the responsibility of the one who collected the data to at least make sure everybody knows they're supposed to delete it, even finding who it has been shared with can be a tough technical challenge. And at Wirewheel, we're really focused on using the API layers to help companies track that data and then to be able to show and send that signal downstream. But that is a really hard technical issue just because of the way data is shared right now. And I will tell you, from my perspective, we have seen and are working with companies that are really trying to do the right thing. They're trying to use their technology. So I think there are ways that we're going to be able to bring technology to this challenge to help, but experience is going to matter. I mean, experience is going to matter, and you're going to need folks like you and your team, Jocelyn, who can bring the experience of working with a lot of companies and bring that experience back into the industry, right? So you teach folks how to do that. Do you mind talking a little bit about how you think about that?
No, it's been a really exciting time, actually. We've been pulling in, when we work with a company, we pull in groups that don't normally actually have conversations with each other. Marketing teams, HR teams, IT teams, the lawyers, the privacy folks, the CISOs, and getting them all into a room and talking about what is important to them, what kind of protections they want on their data, how they use the data. Sometimes it's conversations that really didn't ever happen before. You get this group together where they can really, and what comes out of these discussions is how important they believe the customer experience should be. And so many companies right now really want to be differentiators. They want to be privacy differentiators, and they turn to us to ask how they can do that. And some of it is rethinking sort of that customer journey and the customer experience, what they are expecting. And it is a huge pivot for companies. But what is the best part of having this real conversation, bringing together disparate parts of a company, is you get young people in the company energized, and you end up with privacy champions in places that you least expect, who really want to build privacy into their systems, who want to think about a customer experience that empowers their users of either their tools or their this works in banks, it works in the telecom industry, it's happening in the retail industry. Nobody wants to be the company that is seen as as the one that is A, leaking data, or B, on the front page of the paper for using data in a way that really is causing a huge backlash. And that is introducing these really interesting and rich conversations, which I'm excited to be a part of.
Yeah, I think that's very well said. And it's been interesting, your question about what has changed over time. And we both have a free product for consumers and we have the enterprise product, but like what's really changed is that people are people, whether they are working in a personal context or in an enterprise context. And for the 99.9% of these folks, they don't feel like they have stuff to hide. This is not about hiding stuff, but this is data worth protecting. And it's data that when an enterprise has millions and millions of these records, people within the corporation, not just the CISO, but the HR leader, the folks in legal, our conversations too, over the past couple of years, they really have changed from what the heck is encryption to, oh, this is a differentiator for us. This actually is something that we can make a mark in our vertical, not just in healthcare, not just in financial services, but by being great custodians, that actually helps us win business. And I think that's been a major, very real change that is not just in Europe, it's happening here too.
John, this is a good point. So many people, when I used to talk to them about what I was doing, they'd say, well, I have nothing to hide. And the point is, it's not that everybody's out there breaking the law. It's that you're in your ordinary life, you live your life in such a way that you don't necessarily want everybody to know everything. And a good example of that is, you're wearing a wearable device, or many of us plug our phones in the same place at night. So you and your partner plug your phone in the same night, and all of a sudden, your phone's now sleeping downstairs. And the company knows, and then many companies know, before anybody else in your life knows, that maybe your relationship's in trouble. That might be something you're not happy to share, but it's got tremendous value. And so this is the kind of thing, and you said something about age. The perception is that young people don't care. Our research showed absolutely not, that young people care a lot. It's just they're resigned, or have been up till now, to the fact that they need to use technology and there's nothing they can do about it. Well, we wanted to give them an alternative, that there is something you can do about it. That there is a new kind of vision out there where you can use the technology and have control over it.
Did you see young people actually petition as part of your effort in California, or what was the kind of?
I remember one time we did our focus groups, and there was a guy who was a checkout clerk at a Whole Foods, and all tatted up on here. And someone said something about free services. He said, hey, it's not free. I'm paying with my eyeballs. And and he was talking about a big social media company, and I'm like, hey, everybody gets it. Everybody understands it. You don't have to be, everybody who uses technology understands they're paying in some way, and that the company's acquiring their data, and they feel like they want some control over that.
And if you don't mind, I have to ask Alistair while we're here. Can you believe you actually got it passed? So you were like sitting in your living room at one point, and you thought, okay, I care about this. So you went and researched it, and then you got a law passed through a referendum. Does it shock you that you got it done, or were you surprised about the way it went?
So short answer is yes. By the way, the referendum was going to happen, then it got passed through the legislature.
Yes,
right?
No, I apologize, right.
But the thing is, I happened to get lucky and be in the right place at the right time. This is bigger than any of us here in this room. All of us get vaporized. This is going to happen. This is a sort of civil rights. This is an anti-smoking. This is a societal movement. It's going to take the world by storm. It is taking the world because people are fed up with this idea that their data isn't theirs, that someone else owns it. That they're living their life. You have this implicit sort of requirement in life. You have to be part of the technological revolution. You have to have a cell phone. You can't get a job without a phone. You have to use email. And in so doing, you share your entire life, your most intimate secrets, with hundreds of companies you've never heard of, that you've never chosen to do business with. So I think that this is an idea that the train has left the station. I happen to be at the right time in the right place. It would have been someone else, I think, without me. So.
And I think what's really interesting about this is that in Europe, the belief has always been that a company is just a data stored, but not really the data owner of individuals' personal information. That philosophy is really starting to pervade laws in Asia in South America. And in the United States, I think there had been a growing population of individuals that after breach after breach, and then another breach, and then another breach, really feel like their data is no longer their own, and they want to have that control over where it is and what people are doing with it. This is a first step in that, I think. One of the really important underlying principles of this is that the data is secure. What I find interesting about both the GDPR and the CCPA is it's not very prescriptive in what you need to do to keep data secure. There's a lot of threat for fines and class actions and private rights of action for failure to keep data secure. And data security is really an underlying, a necessary requirement to have data privacy. One of the options of keeping data secure is to either anonymize it or encrypt it. John, can you just tell us a little bit about your thoughts about data encryption and how companies really should be thinking about data security?
Aslan, for sure. And just to build off of what Alistair and also Justin were talking about, what is so powerful about both of your approaches from a technology perspective and also from a legislative perspective is that you focus on simplicity, right? It's a fundamental law of physics that a simple machine is more powerful than a complex one. So, really turning the focus to the fact that enterprises are ultimately custodians of the data of not their users, but their customers, I think is foundational. And part of that, and you touched on this before, if you go back to the many, many data breaches that have happened, if there were easy tools, if that mindset was in place, then I think a lot of the damage and a lot of the data that is in the hands of the Chinese and hackers and many others would not have happened. And where Virtue comes into play and where I think companies like ours come into play, we are foundationally a data-centric security company. So what does that mean? We've spent a lot of time going back to my brother's time at the NSA, figuring out how to make it seamless to protect all data, whether it's stored on-premise, in a hybrid cloud system, in the public cloud, as data is being shared with third parties and then also individuals. How do you make that persistent so that you can set up policies so that only authenticated people and systems and companies can access that content? And I think for a long time there was this kind of fog of, this is so hard, this is so expensive, the cost of a breach actually doesn't impact me, that companies that are doing a lot of other things, CEOs and CISOs had a lot of other problems. They didn't really focus on how to protect what matters, which is the data. And I think that's what's really changed. And I think what's pretty interesting now that we are where we are today is that the US is beginning to regain a real leadership mantle on this topic. And I think that's what's going to have to happen for us to keep this simple in a way that we don't stifle innovation.
And Jocelyn, if I could just jump in, when you say that we weren't prescriptive, that's by design. One of the things that I was really conscious of doing this is technology is moving fast. To the extent that you say, here's how you authenticate, or here's what real security looks like. I mean, in 10 years, it will be a completely different world.
Exactly.
And so I wanted to make sure that we put in place a framework that we don't have an FTC here, but we have the AG's office, and we gave the AG's office the power to write new rules to ensure that the law can live with the times. But again, going back to what John said, we, by design, didn't want to make this very prescriptive. And so this tech kind of mantra, oh, you're going to kill innovation. No, we're not. Look at these two companies. They're employing people. They're offering solutions. There's going to be a lot of innovation around how best to keep all the good things that we all love about technology, and also give people the sense that they're in charge of their own data. That's
Do you know what's very exciting about having a new law to be able to introduce to teams is in companies is that you really can engage individuals from businesses, not just within the cyber community of a business, the marketing teams, the the PR teams, the HR teams, everybody starts to become knowledgeable about what's important about protecting privacy.
It was clear to me all along that as soon as you have a law in California, it's almost impossible if you're a big company to say, hey, you Californians can enjoy this right, but you in Texas or you in New York don't get that right. That's not going to fly. And so I hope there's an analog. If you think about the air resource, the California Air Resource Board, CARB, it passed laws in the late 60s and early 70s around car emissions that then became the standard for the country. And they are today the standard for the country. And we'll see what happens in the federal government, but my hunch is that if the federal government does not pass a law that preempts California, this will become the de facto national standard.
So Alistair, you just talked about the right to know. Justin, how are you working with companies in being able to use technology in order to help companies implement a right to know?
So the right to know is, as I mentioned, a really fundamental issue. And I'll tell you what it looks like on Wirewheel and how we use technology to actually help companies solve the problem. One of the main things we focused on is it actually takes people to protect privacy. If you say something like you're going to plug it in and it's going to magically happen, that really doesn't work. And I'll tell you one pretty simple reason why. When you get into things like intent, what are you using the data for? What is the purpose for it? You can't find that by just plugging in some magical tool. You have to actually ask and understand it, and you need people to be making judgments around it. So one thing we focused on is making the technology usable by people who are non-technical. You have to have a way that when you're interacting with your environment and understanding where you're storing it, where it's being processed, and what it is, that a non-technical person could look at that single pane of glass and actually see it visually. You have to make it so that people can look at where the data is being stored and where it's processed and who the third parties are and connect those dots in an intuitive way, because otherwise you can't see how the data is flowing. Even when it comes to what data you're collecting, this is a hard problem. I mean, it really is, because you have lots of different ways in which companies store data and transfer it between them. So what we've done is we can plug in at the infrastructure, so like cloud layer, we can plug in there. We can also plug into the data stores underneath it, and we can leverage other technology. And we pull the kinds of data that a company is actually collecting into a user view that they can actually label it, group it, and determine how sensitive it is. Because our fundamental view is if a person can do that, they can build something and a view of the data that another person can understand. I mean, one of my biggest points of frustration is a lot of companies right now really care, or say they care about privacy. And if you go to their websites and you type in privacy, the page that comes up is not understandable to most people. It's like a big block of text. It's hundreds and hundreds of words long, and people don't really understand what's going on. So our goal is to make the technology that gives a nice, easy, simple to understand pane of glass to understand where the data is, what the data is, so that a person can build a view for consumers and for people who are using these services, so that they can actually, the consumers, the people, can actually understand what's being collected about them, where it is, how it's being used, and why. And that's what we're really trying to solve on the platform.
That's great. Alistair, you just talked about the right to have your data held in a secure fashion. John, can you speak a little bit about what you've been doing with Virtue to help companies keep that data secure?
Yes. So we do it in a number of ways. In the context of the CCPA, when you think about putting the user first, putting the human first, which is really what Virtue's been all about. How do you make end-to-end security easy for the end user and for the enterprise? Email, file sharing, bulk data transfer, we do all of those things. But at the end of the day, what we have the opportunity to do here is get rid of just all of the cookie notifications, which is what you kind of get out of GDPR, but actually give consumers insight. Justin's doing a great job of that with Wirewheel. We have a very interesting integration with Wirewheel. But at the end of the day, the consumer needs to have access to what that content is. So How do you get that information from the company to the person? It can be in the portal, it can be shared via email, and it's about how you really enable that whole workflow to be dead simple for the company whose responsibility it is to secure that content, and so that you don't have lawsuits coming through the private right of action, which is a pretty big deal. I think a very helpful deal in terms of driving change. But at the end of the day, you want to secure it.
A very big threat.
A very big threat. I think it's between $100 and $750 per consumer per issue. So if you think about what just happened at a very large hotel company, and you're talking about 375 million passport records, those are big numbers. So encrypt it, but then also if there's a request from an individual to understand what's happening, make it dead simple for them to get access to the information, whether they want it by email or if they want to go to a platform.
Do it in a way that can protect the data so it won't be another additional possible leak.
I mean, look, that's exactly right. If you think about why privacy is important, it also helps security. 120 billion a year is spent on cybersecurity solutions. Some are helpful, but there's a lot of overhead when you are continuing to invest in perimeter-based or endpoint-based solutions, when at the end of the day, what you really want to do is probably move to the cloud and secure the data and secure the data itself. One of our big banking customers, very forward-thinking, has moved all of their workloads into the cloud. He said the CISO, they have 180 different security solutions. Really what they want is they want data protection, and they want the efficiencies of the cloud, and that reduces cost. It reduces risk, and it improves the customer experience.
That's a really important point, John, and I'll add just a couple quick points. One is we bring the ability to monitor, even for small businesses, whether your data is encrypted at rest and in transit. So we actually alert you if somehow that's been turned off. And as Alistair can tell you, encryption is one of those features that companies just have to bring to the table. You got to take care of your customers' data. And so by just letting you know you may have moved data into an unencrypted environment, either at rest or in transit, that's critical. And we bring that technology to small and growing companies.
I think, Jocelyn, one of the things about this is just what Justin was saying. This is going to require any company over a certain size to treat its data differently than it has up till now. And so the way the law works is we didn't want to write it saying that if there were a data breach, you're liable, because that felt unfair, because if the full weight of the Russian government comes after some company that's doing their best, that felt unfair.
Yes.
If they were then held liable for a data breach. So what we said is, look, if you encrypt it, if you redact it, take away the personal information, or if there was a pre-existing California legal standard, you had reasonable policies and practices in place to protect the data. That also qualified for getting you out of the liability if there were a data breach. Again, we're trying to incent companies to do the right thing. And if you can't keep your data secure, you can't keep it private, right?
Alistair, what's going to happen now for companies between now, January 2019, and when the law is going to come into effect January 2020?
Well, candidly, we're in the middle of the legislative session. We just started in January, and so between now and September, there's already been bills introduced that would effectively try to gut this CCPA. It's frankly a little disappointing. What I would say is that there are, in my experience, I've encountered companies that kind of get it and understand it. We all kind of have heard some of those companies in the headlines talking about privacy being a human right. And then there are companies that don't. I think that really it's odd for me as a business person, but I think there's this sense if they put their fingers in their ears and scream loud enough, they can make it go away. And they talk a good game, and yet they continually are seen to be doing things that are not necessarily putting the customer first. They kind of put profits first. And I feel like, so there's going to be a pitched battle during the remainder of this year. Again, I come back to the fact that we had 80%, consistently over 80% approval. We passed both in June and in August of 2018, we passed out of both houses of the California legislature unanimously. Not a single vote against at either time, both the initial bill and the cleanup. That's a long way of saying there is uncertainty about could the law be amended this year, and there are certainly people on the sort of I would say, the looking backwards side of things that want to amend it and kind of get rid of it. And then there are a whole bunch of people, me included, who want to protect it and keep it where it is. The Attorney General is tasked with issuing regulations around certain areas, and then it goes into effect next January. And then the Attorney General is prohibited from any kind of prosecutions or enforcement of the laws until July of 2020.
So the virtue is based in a downtown DC, and I would just say, to your point, the close your eyes and the block your ears and hope that this is not going to come into effect, I think is wishful thinking if you think of the leadership that Mark Warner and others are taking on this topic. And so I just think it's really important, now in January 2019, that companies are really getting their arms around this. And I think the only place where we might disagree is you were very thoughtful about making sure that the revenue limits and that the user limits really make sure that mom and pops are not impacted. And I think that's right. But I think any aspirational company that has growth aspirations should not assume that those limits are not going to protect them. And there are, obviously ways to kind of get out in front of this now, so we don't have what we had with the GDPR last year, which was a complete melee around February, March, April before it came into effect. I mean, now's the time to start to really think about this. So.
And that's a good point. PwC, we have hundreds of companies that we're working with right now, some who had to implement GDPR, and so we're a little bit ahead of the game. Some really did not have to and realized that the ship has sailed, that if they don't really focus on California, they're going to have to start thinking through what's going to happen in Washington State, in New Jersey, and other places where they're already talking about data privacy laws. Additionally, the federal government may not act today, but if you think through some of the fundamental requirements that you've put forth in this law, to make sure that people understand what their data, what's happening with their data, and that companies keep it secure and know where it is and know who they're sharing with, and make some choices that are fundamentally data protective of data, that they're not going to be able to function in the United States or globally, because they're going to be at a disadvantage. They won't be able to work with vendors, with third parties. They won't be able, they will lose customer base. They will put their companies at risk of significant fines. And so what we're seeing is that companies are starting to roll up their sleeves and figure out what to do. Having companies really focus in early 2019 about finding where their data is and what they're collecting and who they're sharing with this is really going to be fundamental for them to be successful in 2019.
Yeah, my sense is, look, around the world, people want the same thing. They want to know what companies have collected on them. They want to have some control over it, and they want it kept safe. And so if it's not this, it'll be something else. I think that regardless of the flavor of it, companies need to get organized, because they're going to have to do this around the world. And it's really no different than sort of other, as I said, sort of societal changes that have swept over different industries, where there was safety in cars. Think back 50 years ago, there were hardly any safety requirements. Now try selling a car without airbags. That started off as a regulation. Now it's just what the customer expects. And the customer would freak out if you said, "Oh, sorry, I'm not going to put your airbags in your car." So I think that the companies need to get ready for this. That's just the way the world's moving.
I think it's really important what you said, Alistair. And as I was thinking about it, this is an important forcing function, and you've seen other states start to follow, which has really brought the federal government into looking at privacy legislation. From my perspective, what is happening around the world, if the United States doesn't start leading on this issue, is that somebody else will. That's really what's going to happen. It's a choice. Either the United States is going to engage, and they're going to start leading and showing some of the ways it should be addressed, or GDPR or something else similar to that will start filling all over the world. And we want to be involved in that conversation. You want to start talking about ways that you can solve it. And I always come back to the perspective that the United States is the country of the Fourth Amendment. we've been focused on privacy since the founding of the Republic. We want to be involved in this discussion, and I think it was a really important thing to be moving in that direction, through the California Act.
And Justin, one of the things that's interesting that you said about this, around this, is you've pointed out that if we don't do something in this country, because of you negotiated Privacy Shield between the United States and Europe, but your point has been, which I find compelling, if the United States doesn't do something, they're going to be left out, because all these other countries are going to join a regime, and they'll say we can't do business with people who don't respect privacy.
That's exactly right. That's exactly.
You have both really touched on how important this is from a global perspective. If you just think about what then we were both dealing with in a lot of these international negotiations, where the trust issue, right, has hurt us in many ways when you think about the fundamental efficiencies of the global internet and the U.S.'s leadership there. You are now talking about the balkanization of that, and it's due to foundationally this issue about not thinking about data as being the property of the creator of that. And if we can start to get in front of this, we can start to win in these international forums to really preserve what is great about all that we've developed over the past 30 years.
Could not agree more.
So one of the things that we've been doing is not only talking to company C-suites about how they can make this cultural shift, it's how they can translate that into giving their employees a feeling of empowerment, and how they can help change the culture, how they can help work with technology.
So interesting, because we got our start as a company. It's funny, we have talked about a lot of the fancy stuff to make things simple so you can comply with the CCPA. But actually, at the end of the day, we got started because you could revoke an email. So if you sent a customer list or PHI and you hit reply all by mistake, that's massive risk. But to give the employee the power to hit the big red revoke button, like that matters.
And look, Alistair and John have both talked about why they really got started. I probably have two that are similar to that. One is, even now when I talk to friends or family or my kids, and you ask very basic things about, do you understand what's happening with what do you even know that you just gave away some information about yourself? I don't think people understand. I don't think there's enough information, and I feel like that's unfair, fundamentally. I just don't think it's right. And then, from my perspective, and Jocelyn, you saw this too, and John, you saw this, you're certainly seeing this, Alistair, like all around the world. This is just a movement, and if we can't make something so that we can enable people, who are trying to do the right thing to do the right thing, we're going to put companies that are actually trying to solve big public problems. I mean, honestly, they're trying to solve problems and they're trying to help people. We're going to put them at a disadvantage where they're not going to be able to do business. And that's something that really bothered me. And so really coming at it from the perspective of the human beings at the end of the day, but also companies that are trying to do the right thing is why I'm, sort of excited about the idea of innovation in this area,
Alistair, could you tell us a little bit about your thoughts behind the right to say no?
Absolutely. At some level, that's sort of the whole fulcrum of the law. You have on one side, you have the transparency, the right to know what's been collected, and on the other, you have the right to make sure that it's kept safe the way you'd want it to be kept. And right in the middle is that control piece, and I think that's really one of the most interesting parts of the law is that we want to empower consumers to take control over their information, and we had to draw a line somewhere. So our line was giving the consumers the right to say to companies, don't sell my information. This is, I think, is going to be a longer discussion. I understand we're going to do this the next time around, but the interesting part of our approach is that unlike the European Notice and Consent, GDPR, we don't have a consent requirement on the collection, but we place the consent over what happens to the information once it's in the possession of the company.
This is going to be a really interesting topic. I think a lot of companies have questions and are really looking to really flesh out what that means, the right for an individual to say, stop selling my data, which could also mean stop sharing it with third parties, and what should companies do in order to be able to comply with that. And that's something for our next discussion. Thank you all for joining us today, and we look forward to speaking with you again soon.